It is the late Mr. Sedgwick.
All right. Yeah, I know you were just up there with him and they just brought him back. So we're all good.
He signed the petition. I can email it to you like within 5 minutes.
Well, I think Miss Finney sent me the agreement. So my understanding is he's pleading to one, which is a level 5 drug, and they're dismissing the other count against him. He has to get a substance abuse eval, follow the recommendations. Both of you are recommending the aggravated box. And did I understand that we believe that he's presumptive probation?
Yes, Judge.
That is my understanding. Yes, that is exactly it.
All right. So, and just so I know, make sure that I'm right. On a level 5, the maximum's 42 months and 100,000.
That is correct.
All right. That's what I thought. Okay, we'll get started. Before I call the case, Mr. Anderson, just let you know what's going on. To take up this plea, I'm going to have to ask you a bunch of questions.
Yes, sir.
If I ask you something you don't understand, you tell me that, and we talk about it until you do understand, or we make sure that we're both on the same page. If at any time you want to talk to Mr. Sedgwick in private, I have a way of doing this on here. I can put you in what's called a breakout room, and you go into a private room, you can talk to him before you answer a question if you want. All right?
Okay.
All right. And the first thing, I'm going to call the case, and then I'm going to have you sworn in. So we'll go ahead and get started. I'm going to call case number 2021CR106, captioned State of Kansas versus Matthew Anderson. Would the parties announce their appearances, please?
May it please the court, Assistant District Attorney Bianca Finney on behalf of the state.
May it please the court, the defendant appears virtually on Zoom with his counsel, also virtual, Bill Sedgwick.
All right, we're here set down to take up a plea. I would note for the record that I haven't got the plea petition yet, but Mr. Anderson was farmed out. They brought him back in, and Mr. Sedgwick just had the chance to go over that plea petition and get it signed this morning. So he'll provide that, but I'm well advised as to what the plea agreement is and the maximums possible. So I can proceed with that. Mr. Sedgwick will email the agreement to the parties after the hearing. Mr. Anderson, as I told you before we went on the record, I got to ask you a bunch of questions. To do that, I need to have you sworn in. So if you'd raise your right hand, please. You're muted.
You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Thank you.
Go ahead and put your hand down. Mr. Anderson, how far did you go in school?
11th grade.
You read and write okay?
Yes, sir.
All right. As you sit here today, I know you're in custody, but are you under the influence of any alcohol, drugs, or prescription medicine that might cloud your mind, keep you from understanding what you're doing today?
No, sir.
Feel like your mind's clear?
Yes, sir.
Do you know what you're charged with?
Yes, sir.
All right. And you know you don't have to change your plea from one of not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial on those charges. You understand that?
Yes, sir.
At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You would not have to prove
Your Honor.
anything yourself. Yes.
Your Honor.
Plea,
We
preliminary
did waive
hearing.
limit, and I didn't go over it much with him, but just
Okay.
a reminder.
So we'll take a little detour from the plea right here. Along with that right to jury trial that I was just talking about, you also have a right to a preliminary hearing. That's a hearing before a judge that takes place before trial. And at that hearing, the state would have to put on enough evidence to show probable cause to the court that the crime was committed and you committed it. You have an absolute right to that hearing. However, it would kind of seem like, I don't know, not necessary, given the fact that we've reached a plea agreement today. Do you have any questions about that, Mr. Anderson?
No, sir.
All right. And would you want to waive that hearing to go forward with this plea today?
Yes, sir.
All right. Mr. Sedgwick, any problem with your client waiving preliminary hearing today?
No, Your Honor.
Ms. Finney, on behalf of the state, you also waive preliminary hearing.
I do, Your Honor.
All right. I'll find that both parties have waived preliminary hearing. I'll make a finding of probable cause on the charges as they exist. Bind the defendant over for trial. For the time being, enter a plea of not guilty until we finish with our hearing today. Okay, so back on to where we were at, Mr. Anderson. I was talking to you about the jury trial. Not only would the state have to prove you guilty beyond a reasonable doubt, you would have the assistance of Mr. Sedgwick throughout that trial. He would be able to cross-examine and confront all of the state's witnesses, challenge their evidence. He could call any witnesses you wanted called, and if they didn't want to come to court, he could use subpoena power to make them come to court. At a trial, you would have a right to testify, but you'd also have a right not to testify. And if you decided not to testify, the state couldn't use that against you. In other words, Ms. Finney couldn't get up and argue to the jury, well, ladies and gentlemen, you should find him guilty because he didn't get up and tell you his side. Do you understand all those rights at trial?
Yes, sir.
All right. Also, so if we had that trial, at the end of it, you were convicted, you would have a right to appeal that conviction to the Kansas appellate courts. If you didn't have the money to do that, a lawyer would be appointed to do it for you. Do you understand that?
Yes, sir.
All right. Now, if we go forward with this trial, or I'm sorry, with this plea today, there's not going to be a trial of any kind. And you'll be giving up all those rights I just talked about. You understand that?
Yes, sir.
All right. Now, Mr. Sedgwick tells me he went over this plea petition with you and that you understand the terms. Well, let me ask you first. Did you get a chance to read that petition with Mr. Sedgwick, and did he answer any questions you might have?
Yes, sir.
All right. And he tells me in that plea petition that the agreement was set out, and it is as follows, that you're going to be pleading guilty to count 1. That's the possession of methamphetamine, a severity level 5 non-person drug felony, and that the state will be dismissing the other count against you. I think it's actually count 5 in the information, because the other counts only charge your co-defendants. That in addition to that plea and that dismissal, that the parties agree that you're going to get a substance abuse evaluation and follow the recommendations, and that both parties are going to suggest to me that I give you the aggravated number in the box, but they expect that you'll be presumptive probation. Is that your understanding of the entire plea?
Yes, sir.
Has anybody promised you anything else to get you to plead today?
No, sir.
Has anybody placed any force or threats against you to make you plead?
No, sir.
All right. Ms. Finney, Mr. Sedgwick, what criminal history score do you think that Mr. Anderson will have?
The state believes Mr. Anderson is a criminal history E judge.
Phil, does that sound right to you?
That is, well, he told me that he thought he had 1 non-person felony, 1 drug case. I don't know whether there were more counts. Was it all in the same case?
All right. So here's how it works, Mr. Anderson. When we're done with this plea today, I am going to order a pre-sentence investigation. The probation office is going to take a good hard look through your criminal history and find out what it is. It sounds like they're not exactly sure, and you might be an E or you might be something less, but even if you were an E, you would still fall in that presumptive probation box. You understand that?
Yes, sir.
Okay. Now, for today's purposes, I have to, I don't have enough information to know what your criminal history is myself. So I have to assume you have the very worst criminal history possible so that I can advise you what the maximum that anybody can get for this crime is. You understand that?
Yes, sir.
The maximum for this crime is 42 months in prison and a fine of $100,000, and that would carry 12 months of post-release supervision. You understand that's the maximum in this case?
Yes, sir.
All right. And you also know that even though I listened closely to everybody's recommendations in deciding what the sentence should be, I'm not bound by their agreement or their recommendations, and I can give you any sentence that the law allows me to give you. You understand that?
Yes, sir.
All right. Do you have any questions about anything you and I have gone over today?
No, sir.
All right. And knowing all this, you want to go forward with this plea today?
Yes, sir.
All right. Mr. Sedgwick, do you know any reason why your client should not plead guilty today?
No, Your Honor.
All right. Then I'll ask you, Mr. Anderson, as to count one, charging you with possession of methamphetamine, a severity level 5, non-person drug felony, how do you plead, guilty or not guilty?
Guilty.
All right. Now I'm going to ask the state to tell me what they think their evidence would be if this case went to trial. I want you to listen closely because when they're done, I'm going to ask you if that's what happened. Okay?
Yes, sir.
Miss Finney.
On, excuse me, on February 6, 2021, officers were dispatched to 50 North 61st Terrace, Kansas City, Wyandotte County, Kansas, in regards to a stolen auto. The complainant advised that there were two males in a gray Kia Soul. The passenger of the Kia Soul, Matthew Anderson, was seen walking away from the Kia when officers took him into custody. While, excuse me, while performing a search of Mr. Anderson, a glass pipe with a white residue was found on his person, along with a small baggie with a white rock-like substance believed to be methamphetamine. Mr. Anderson admitted to having a glass pipe and the rock-like substance in his coat pocket. On February 8th, 2021, Officer Peters, who is certified to operate the True Narc machine, conducted a presumptive positive test on the off-white rock-like substance with the True Narc machine with a serial number TN6148. The analysis of the substance tested produced a positive result for methamphetamine, and this all occurred in Wyandotte County.
All right. Mr. Anderson, is that what happened?
Yes, sir.
All right. I will find that the defendant has freely, voluntarily, and intelligently entered into his plea of guilty. He understands the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and the defendant has acknowledged that factual basis. Therefore, I will find he is in fact guilty of count one, the possession of methamphetamine, severity level 5, non-person drug felony. Pursuant to the plea agreement, count 5, the possession of paraphernalia is dismissed. I'm going to order a pre-sentence investigation and continue this sentencing. Let's take a look at our calendars, people. I can do either anytime on May 3rd or 11 o'clock or later on May 7th.
I'm available either date.
All right, Mr. Sedgwick, which works better for you?
What are the times on the May 3rd?
9, 10, 11, anytime that you want there.
Okay. 11 o'clock is fine for me.
All right, let's do May 3rd at 11 o'clock by Zoom. I'll get the invitations out. Mr. Sedgwick, do you have a motion as to bond?
Yes, Your Honor. Given the fact that he is presumptive probation and the fact that he needs to get the substance abuse evaluation, which I believe will be easier to do if he is out. I think he has a business which he can go to. He does work for himself, and I believe that he's employed and will take care of it. So, Your Honor, I would ask that he be granted an OR bond.
All right, Ms. Finney.
I have no objection to that, Judge.
All right, here's what I want to do. I want to ask pretrial services to get him out first, because I'd like to see some supervision. And in fact, they might even be able to help him arrange his substance abuse evaluation. But if they don't agree to supervise him, I'll probably OR him anyway, because if he's presumptive probation, there's no sense in keeping him in jail. All right, Mr. Anderson, pretrial service bond is gonna leave you an information sheet so they can take a look at you and screen you. Yes.
They already sent me one for house arrest, and it didn't work. I didn't get. They sent me one for house arrest.
Did they
pretrial,
tell you why you were denied?
Because they told me because of my job status, because I was in here and I couldn't show proof of income.
All right. Well, I'm not gonna ask them to put you on house arrest. I'm gonna ask them just to put you on pretrial services, which means you don't have to get the collar and wear it at home or anything like that. You just probably have to check in with them every now and then. If they want you to come in and drop a UA, you have to do
I
that.
did that before.
Okay. All right. I'm gonna ask pretrial to take a look at you. They'll give me an answer today. I assume. And then hopefully they'll get you out. If not, I'll find a way to get you out, okay? There's no sense in you sitting there, particularly if everyone agrees you're gonna be presumptive probation anyway.
Yes, sir.
All right. Other things for our record today.
Nothing from the state, Your Honor.
Nothing by the defense.
All right, have you, if you could send Miss Finney a copy of the plea petition for her signature, or if you know, she just wants to
Sure.
get back to you electronically and approve it, then get it over to me, I'll sign it and get it filed.
Okay.
All right, and the other thing, Phil, when you did it, did you do a PSI request?
PSI. Yes, I did.
Okay, if you would do you know who to send that to, or you just need to send it to me and I'll send it over?
I don't know who to send it to. If you want to tell me, give me
Okay,
an email
I'm gonna
address
go
or I'll
off our live stream, so